Fresh matter, my lord, for the tomorrow, there with the trial court executing FTP proceedings against the appellant, my lord. Executing FTP proceedings against the appellant, my lord, in this case. Tomorrow is a date given, man.
Last yes.
Fresh matter, lordship.
No, madam, year,
Yeah,
madam.
the execution listed.
1 week before, lordship.
Or
Tomorrow, the trial court executing the FTP proceedings, lordship, for the correction.
Totally
the
memo
other
to-
side,
Other side, fresh matter, lordship.
you inform the other side, you must inform the other side.
I'll inform lordship.
No, madam, fresh.
For tomorrow, lordship, kindly. RFA, lordship, for it.
Yes.
My lord, on review petition for admission. My lord, sir, the matter pertains to the land acquisition proceedings. Yes, my lord. Please, my lord.
For the bench.
My lord, sir, this was your lordships and justice, the other bench.
You have to mention it before the honorable chief justice. You can't take it out. Okay.
I shall, please.
My lords, this is a commercial appeal. I appear for the respondent, appellant is the state. 2023, my lords, commercial.
You'll see, when do you want?
My lords, if it can be tomorrow, my lords.
You'll see.
My lords, this is the second time they have taken, they have come on appeal. So it is with respect to funds, my lords. Much of it. Yes,
After vacation.
obvious.
For adjournment. Page number 418. Page number 5, 19 to 24.
No, still number 22, my lord. I seek an adjournment, please. I've informed the other side, my lord. I've informed, my lord.
Eleven, 12 to
Great.
page number 6, 20.
Both are not connected. No. Yeah, I'm for the edition.
Appellants.
Who is the other side? I inform chair. We will first inform, then mention. Serial number 25. Yes. Agreement did not take place in the. They inform the other side, can you fix a date for hearing of the. Who is the other side? To be informed. When we are hearing for the respondent. Others. Yes, they will counsel for the final stage, there is a settlement talks have failed. And hence the accordingly,
12th
My lord,
February.
serial number 26, my lord.
keep the date first.
Please.
Serial number 25, 12th February.
Next.
Serial number 26, my lords. I have informed the other side, learned senior, Mr. Puttegowda, my lord. I have informed him. My lords, the interim order may be extended, man. 26. Much over.
Lords, serial number 27, my lords. Serial number 27, my lords. I'm appearing for the appellant. There is some personal inconvenience for the arguing counsel. May I request, my lords, I have informed. Yes,
12 to
much obliged.
Serial number 20. Serial number 28. 28.
Sure.
I'm for serial number 28. I appear for the respondent, my lords. I've informed Jagdish.
Yeah, tell us what is 29 request. You be appellant. Have you mentioned? Inform. Also for the respondent, respondent number 1. Seeks an adjournment by stating that he has informed the counsel appearing for the appellant. Yes, now 28.
13,
My lords, I appear for the respondent. I've informed the counsel for the appellant, Mr. Jagdish Baliga. Maybe at any time after the vacations.
Appearing for appellant, Your Honor. Okay. Colleague इधर है.
sorry, sir.
20.
13 to
Yes, indeed. You are me. Yes.
Jagdish
Yes,
Paul.
yes, sir. Okay.
serial number. Give your name.
So,
Serial number 24 months.
yes. Twenty-four.
Please, madam. I am for appellants. So, other side is here. Appellant, madam.
Respondent. He seeks an adjournment. The adjournment is sought by the counsel for the appellant,
Please.
which request is not opposed, adjourn to.
12 to
In serial number 23, my lords.
Yes.
Other side, there is no, there is no mentioning in the cause list, my lords.
We don't-
I'll, please, please.
Pardon? Yes. You have informed.
Yes, ma'am.
At the request of counsel for
Respondent.
respondent for an adjournment by stating that she had informed the counsel for the appellant who had no objection.
your name, your name.
We just give you- just-
12 to,
just
12
note
to,
the date.
12 to, madam, 12 to.
How possible. Next.
Serial number 1. Serial number 1, Sri Prakash.
The office objection is that translated copy.
10 to
Please,
Why is it translations also?
please, madam. Right, please.
The translation of the Kannada documents, whatever document you are filing, you will file it to e-file.
Please, madam.
You filing any documents?
No, my lords. I will, I am seeking.
File. File the appellant shall be to e-file. Okay,
Please, my lords.
yes, next,
serial number 2, Sri MJ Alva.
just say that.
For the appellants, please, my lords. My lord, 2 weeks' time may be given. We'll take steps for R2 and R3, my lords. It may be dispensed with, my lord, but R2 is a guarantor. So we might have to take. It's come as not claimed, my lords. We'll ascertain the right address and take steps as required. The borrower has been served, my lords. The guarantor hasn't been served.
It appears respondent number 2 has been served. Respondent number 2 and 3 have not been served. We stop respondent number 3 being arbitrator. The notice to the said respondent is dispensed with. To stop repression, it will be issued for service on the respondent becoming law.
17 to serial number 3.
Grateful, my lords.
Respondent number 2 has been served. Respondent number 1, I will take steps, my lord, I will. So yes. Grateful to you.
17 to
Wait.
serial number 4, Sri Rupakshaya.
Appearing for the appellant, my lord, respondent number 3, my lords, is the, my lord, is the officer of the National Highways, my lord. My learned friend is appearing, my lords.
Respondent number 3.
My lords. 1 and 2 is also National Highways, my lord. Respondent number 1, my lords, is the project director.
No, my lords. One is the project director, my lords, of the national highways, my lord. One, please, my lord. Three, my lords, the notice is refused. Three is the technical manager of the.
Respondent number 3 as well. Respondent number 3 as well. Submission is taken on record. Okay. We notify the appeal now.
13-2.
Right.
Bill number 5. 5, Shri Vikar Ahmad.
Paying for the appellant in this case, my lordship.
Sir,
I am for the respondent number 2, Your Lordship. Yes, well, respondent number 1 is the arbitrator, my lord. Respondent number 2, I am appearing, my lord.
One is the
Respondent one is the arbitrator, my lord.
Yes.
Yes, my lord.
The arbitration. There is a dispute. Are you okay for 2?
2, my lord. I am Suresh, my lord. I am colleague. My wakalit is also there, my lord. I will, my lord, address is, the Malleshwaram address is shown, but the authorized officer sits in Vijayanagar, my lord. That's why. I will complain, my lord. I will complain. I will file fresh wakalit, Your Lordship. Please, my lord. My lord, short date may be fixed since he is paid in 2012, they are not payment, my lord. Notice is also served. 47 lakhs is due. 2012 is the last payment, Your Lordship.
12-2.
Much
Serial 6, serial number 6. Vin Kumar.
I have to collect the correct address, my lord. I'll take steps in a week. Respondent, my lord. It's a branch office. They have shifted.
You should appear for R2 also. R1 is the main office, no?
Yes, house, sir. The branch.
Here in Bangalore.
7. Shri Raghavendra Prasad. 7.
Appearing for appellant, Your Honor. Kindly reissue, Your Honor. Steps for, I will furnish the PF, Your Honor, today only.
Fourth of March.
Sorry, my lordship. Serial number 5, interim order may be extended.
Interim order can be extended. Here, the stay as your.
Last time. Is there an interim order gets vacated? Yes, it is. Yes, it is. And the last opportunity of operation is we should put on this one. In 7. Okay. Who is there? 5.
5 Vikar Ahmad. Serial number 8. 4.
This matter apply for the appellant, needful done minutes. R2 is the arbitrator minutes. Process paid today minutes, needful done. Yes, please. No, duly served. Duly served. R1 duly served.
Thirteen two,
Oblige, please.
serial number 9, Sri Ramesh Chandra, 9.
For the appellant. An application for amendment was filed. Some typographical error was there. The column.
I have no objection for IA number 1 of 24 amendment of first title. I have no objection, my lord, appearing for.
What happened when rank of the parties while mentioning some other, it was a copy and paste, it was there. AS 52 that instead of AC 10 of 2000, it would have been 8, AS first page, my lord. First page itself. Rank of the parties. Their number is mentioned wrongly. Top of immediate letter before second additional. Yes, I have stated in my application.
The application has been filed with the following, under authorization, rule 17, in section 1.5 of the CPC, the following. The counsel for the appellant states that by inadvertence, the rank of the parties in the court title was mentioned as AC 10 of 2015.
AS 60 of 2014 instead of AC 10. AS 62 is not filed by us. It is somebody's top of the, immediately after arising out of before second additional, top cost title below. 62 of rank of parties. Below the rank of the parties. AS is not mine. No. AC 10 of 2013 instead of I have mentioned as.
Which page is that?
First page. Left, right hand side, my lord. Rank of parties. Their MFA and AS.
Parties. First, MFA had it as AS, no. The very reference, very stated AS number 62 of 2015.
That out of AC 2010 of 2013.
It has AC 10 of 2013.
Yes, ma'am.
Yes, ma'am.
Counsel for the appellant is that is allowed to rectify the mistake.
Yes, ma'am.
By hand and by putting the signature.
Much of it.
In this submission, we direct the necessary correction be made by the counsel for the appellant. In the paper book, in both the paper books, by putting the signature. That's all.
Yes, sir.
The application is disposed of. This will become appropriate.
11-2,
Much of it. Please.
number 10, Sri P.B. Raj.
Trial court record may kindly be called for. Much of it.
For the respond 1 to 4. I have filed this application for early hearing.
We are ready, my lord. If court has time, we are ready, my lord.
The only thing is, your lordship, I may just want to point out the order passed by honorable court on earlier occasion. Just a minute. Your lordship may kindly see the previous occasion. The order was passed by honorable court on 26/6/2024. Your lordship. 26/6/2024. Yes, your lordship. In that, your lordship, I have filed an IA-1 because as far as the respondent for concerned, they entered the MOU only for the formation, giving my road for the formation of layout by the appellant, only for that MOU. Now, by virtue of that, the adjacent owner, who was also want to part his land, their daughters have filed a suit before the court, proper court. That matter is pending. So once that dispute is there, this road is not possible for them. to have access to.
I will work
That's
out
why
my
I complete
remedies
it.
there.
So that is the reason.
Why are you bringing it here?
That is the reason this honorable court has recorded subject. Learned counsel Sri G. R. Mohan for respond 1 to 4 is present before the court physically, and whereby the said counsel in this matter submits that the issue emerging in between the appellant and the respondent during the party to the proceeding in these two appeals matter, but the proceedings in OS number 885 is related to suit per party, and this suit is initiated by Srimati R. Vidya, who is the plaintiff therein, and the suit is initiated against the respondent Ramchandra and others on the file of the court of Srimati Devanadi, and the same is pending for education in process. In the meanwhile, submission made by the, now by virtue of that, I filed an application IA-1 for 24 years. Then on the last hearing date, you on 5th August. 5th August, I am filed an IA that since the impossibilities of this contract as far as the road is concerned. So I have received, they are saying that I have received the payment of 15 lakh from one Shiv Kumar, who is in the adjacent connected appeal 20.1, your lordship. So I filed an application that I will return that amount with interest, so that this, as far as this road portion is concerned, it can be sorted. Yes, sir. Yes, sir. And also produce the sketch also. Any short date, maybe after vacation.
Yes.
Yes.
For all the respondents.
All the one to
File the arbitration.
yes, sir.
Yes, ma'am. I have it.
This is an application. And they do for 24. It will be filed by the respondents.
Respond 1 to 4 in the first case.
Respondents 1 to 4 for every hearing of the appeal. So and so appears for the appellant, non-applicant. There is no objection for the appeal being heard and finally. Pending for both the appeals. There's no objection. The appeals are now, what about the connected appeal? Connected appeal, who appears? In the connected appeal, who appears?
No, I am not appealing.
I am for the contesting respondent. He is the appellant.
But that portion is not this, because my portion is only pertaining to road, giving my road. Only to that effect, I am agreeing for settlement. No, I am not. I am not appearing for that. Another one. That is a separate arbitration suit and separate proceedings. Yes.
Yes, my lord.
Just say this. This is a. You are not filed application in that.
They are not at all appearing before this court after the case.
When application has been filed, just when application has been filed by the respondents 1 to 4 in level 7 of 2016, we find there is a connected appeal, which I think we are between MFA 2799 of 2015. There is no appearance for the. Though Mr. Shivanso appears for the appellants in the said appeal, but there is no appearance for the respondent number 1 in the said appeal.
I'm informed she is demised. We have also filed a memo, but nobody is taking any steps for her, my lord. So far as she is concerned. We'll see if necessary steps have to be taken. I'll do that. Please, my lord.
We also state steps to bring the last on the problem. And you have the opposite position till such time. We have last in MFA 2799 of 2020 as brought on the court. The appeals cannot be heard. Both the appeals cannot be heard. We then be notified.
Please, ma'am.
It can be separate because.
And
Because their land, they are not, it can be delinked and.
This is what I, in my memo dated, I have said, my lord, after Mariamma demised, the respondents 2, 3, 5, and 7 in the original arbitration did not challenge the arbitral award. And the other person, their only legal heirs are already on record. I have filed a memo, my lord. Very well. I'll clarify it, my lord. Please. Please, my lord. Please, my lord.
10-2.
We have not allowed their application,
Yes, your lordship.
but till such time these things have to be
Yes.
sorted out.
On the next day in date, your lordship may consider even the other appellant, respondent also.
It had expired.
Yes.
Sir, early hearing alone. Serial number 11. Kishore. 11.
Respondents, my lord.
Here for the appellant in this matter, your lordships.
We had,
Senior counsel is on his legs, your lordships, short passover.
my lords, I'm appearing for the respondent and need a week's time, my lords, more to file my objections. They have raised additional grounds, my lords, in the appeal recently, after 3 years after they filed the appeal memorandum. Hence, I need, it's a voluminous matter, my lord. My lords, it's actually additional grounds. The IA is for additional grounds. I think there's a mistake by the registry to make it additional documents.
Additional grounds. Grounds. Lord, this is actually, my lord, the 34 was allowed and the award was set aside. Therefore, these are grounds, my lord, which you raised in 37 now. To that extent only. Not grounds
A
under
week's
34.
accommodation.
Not grounds under 34.
Whatever they have to say, is 37 challenging 34. Those additional conditions will permit you to
Very well.
stand will come on record so that they can watch.
As
Sure.
a,
We'll file.
The respondents file different submissions. Incorporating their stand on the additional grounds which have been urged by the appellant in IA 2024.
And one more submission, my lord, the paper book which has been filed, I think the documents filed by us have not been incorporated in the paper book in the arbitration. If that may be completed.
Fine to file, if you have missed out something, you just file those, that's.
Definitely, I'm just, sure, definitely.
Is also granted to the respondents to file on record those documents which have not been filed along with the paper book by the appellant.
Definitely.
In the same time period, that is 4 weeks. We will notify the appeal.
12th February.
Great.
Great.
Serial number 12. Sri Sundararaman. 12.
My lord, that's here for the appellant's counsel. My lord, this application is by the respondent for withdrawal of money. My lord, on the last occasion, my lord had permitted us to take the bank guarantee back and deposit the money. We took the bank guarantee back on 5th. My lord, on 10th, we have deposited the money.
Don't have an acknowledgement.
Deposit. No, now your application for it. My lord, there's an application from the respondent for withdrawal of this money. An application for withdrawal of this money. My lord, we permit them to withdraw it, subject to them furnishing a bank guarantee for this, for the like sum. My lord.
Everything together.
Yes.
My lord, we took the bank guarantee back on the 5th. On 10th, we have deposited the money. Lord, I have an acknowledgement here. Yes, my lord, which was the value of the bank guarantee.
also, let us check it whether in the endorsement you have deposited, you just want to check up everything. Now, what do you say? You want to draw?
I want to withdraw and furnish a bank guarantee notes.
Yes.
Just say this.
IA 3 of 24.
Of the respondents, you appear for both the respondents.
Only one, my lords. Respondent number 2, the arbitrator.
Favor of the respondent. This one, they don't pay, and this one.
Yes, so
This one. In favor of the respondent. Subject to the respondent furnishing the bank guarantee to the satisfaction of the registrar judicial. The same be released under the senior counsel for the appellant. Objection. In that regard, provided some security is provided, the bank guarantee furnished in favor of the registrar general office. Submissions of the counsel for the parties.
And not subject to outcome of this proceeding.
No, my lords, it would be one. They are already deposited 55 lakhs in cash.
It's 1 crore 4 lakh.
1 crore 4 lakhs 43,753 rupees 70 paise.
Amount of that is an amount of
55 lakhs, my lords may see my application at paragraph 2. 55 lakhs 18. Yes.
On 26/2/24.
It shall be. State shall give its report on the deposit made by the appellant. The complete deposit made by the appellant till date. And the value of the said amount as of the date. For the next date of the. Let's have it also so that we are clear about the amount. We notify and just give it to the first week of security program.
9th of January.
It,
Serial number 13, Kumar MN 13.
Agreed with the order passed by the section 34 petition by the Commercial Court Bangalore challenging the award passed by the Honorable Arbitrator, contrary to provisions of law awarding an incentive. So Mr. Vasudeva Naidu.
14.
There is a delay in filing the appeal, my lord. 81 days
I'm the
delay.
respondent, Your Honor. I am for the respondent. So I would request the lordship to give me some time to file my objections.
See your application. See your application. Delay of 81 days is beyond 60 days.
Delay in filing the appeal, that there is the reasons for collecting the copies.
There is a commercial appeal. With this application, prayer made.
Prayer is condone the delay of.
81.
They didn't say so.
The para number 4 statement, counsel after obtaining the certified copies of the infant judgment and decree important to collect the same to take steps to prepare an appeal. I will file the better application.
Otherwise, 60 days is the delay.
Yes, madam.
The limitation.
2 weeks time I will grant.
Counsel for the
Much.
12 sir. Still number 15.
My lords, appearing for the appellant in this case, my lords.
Still number 15, sir.
My lords, appearing for the appellant in this case, my lords.
Yes.
We have filed an application for paper publication, your lordships. Your lordships, the earlier notice which was sent to the respondent has returned with an endorsement unclaimed. So on the last date of hearing, we made the same submission. Therefore, pardon, your lordship. Yes, your lordship. It's returned with an endorsement unclaimed, your lordship. It's not served.
Sir, I have one. 17, 125, 24 to 25.
We just say this, the counsel for the appellant shall also file a affidavit evidencing the issuance of the publication. The newspaper with the paper, with the newspaper for the next day.
16. Serial number 16, Vamshi Krishna.
My lord, in this matter, there is a delay of 177 days.
It's the important page in the delay has not been provided or circulated. It was not been given in the Xerox, my lord. I think page 58, my lord, they make the reasons. That page is missing in my copy, my lord. I just request them to.
A copy. So the main reason is that because there was an ongoing issue with the previous council, my lord, because of which they were not getting a timely update. So they got to know that from the previous council, the trial court council. So he got to know about the suit being rejected, plain being rejected. My lord? They, my lord, the plaintiffs over there were going on seeking for this one clarification from the councils, from the trial court councils. But the trial court council was not giving any proper update. It was in September, the plaint has been rejected. But only in the month of February next year, the client finally got an answer telling that his suit has been rejected. So he was going on following up with them, my lord. But it is his counsels to give him the information. Now the counsels have not given the information. He cannot bear the cost. My lord? I'm not sure yet. You need to this one. I understand, my lord, but the party should not suffer for the acts of the advocate. Yes, my lord. On the 7th of July, I have filed this application along with my plaint, along with my appeal.
Did you follow up?
So we got the file in the month of July, my lord, 2023. So there was because of the fees not being paid and all, there was this one files was not being handed over. After we went through the file, we immediately told them that we have to challenge this particular order, and as such, we have immediately come forward and filed this appeal. In the month of July, my lord.
Did he get the file from this council?
It is more or less around the same time, my lord. Yeah, in February 23, he was informed, my lord. Thereafter, because pending dues were there, they were settling the accounts, and then because of that, he was not ready to hand over the file.
After 5 months from the February, my lord, in the month of July, they filed it.
Yeah.
According to this.
After 4 months.
Please.
Yes, my lord, but he has not handed over the files.
And they will not be remedialized because the plaint was rejected on the ground of arbitration. Even if lots of dismiss it on the ground of limitation. The plaint was rejected, there is an arbitration clause.
My lord, in this case, what has happened is...
Section, my lord, the respondent number 2, one, my lord, who is the B.M. Marcel, my lord, has filed a rejection application. Or the plaint has to be rejected because there is a arbitration clause. No, they filed it has to be rejected. 7/11.
My initial contract was with respondent number 1. He is into the infrastructure development, my lord. He gets a contract from the respondent number 2, who's basically Bangalore Metro. So he gets a contract from them. So respondent number 1 places purchase orders on me, my lord. And I accordingly deliver the products as and when required, and invoices have been raised. That being said, my lord, subsequently,
since the page number 58 is not been given
I
to
will serve a copy. It might be by inadvertence.
some may be mistake, my lord, bona fide. Respondent number 1, my lord. So Mr. Harish N.N. is who is in the order.
I appear for respondent number 2, MRCL.
In so far as the IA for condemnation of delay is concerned, of course, I have not filed any objections. I cannot have any objections regarding that. But if the matter has to be heard on merit, then I request that the matter may kindly be taken up after vacation. Because even I do not have the complete set of papers relating to the trial court where all the documents were furnished. I only have the appeal memo along with the documents. So so far as the purchase order and other documents are concerned, they are not available on the file.
Thirteen two.
May I also request the records be called for because their reply was rejected.
17 urgent.
Plus.
Serial number 18.
Yeah, Appellant, Your Lordship. We are filing a memo for withdrawal in both the connected matters. For the Appellant, Your Lordship, we're filing a memo for withdrawal.
Nineteen. Chandan.
The appellant, my lord.
Lords, I appear for the respondent number 1. I filed Wakalat today morning, my lords. I seek a short accommodation to file my statement of objection. Respondent number 1, my lords.
Actually, they have.
Two.
Grateful to lordship.
Serial number 20.
For the appellant, my lord. My lord, I request for an accommodation since senior is out of the country and
Before two. Serial number
obliged, my
21.
lord.
21.
I appear for the appellant in this matter. On the previous occasion, this matter was heard at some length. And just to quickly recall, this is a matter that pertained to an award that was passed. And one of the awards that was passed was in relation to an F form that had to be issued by the respondent to the claimant. The other part of the award related to a sum of about 3 crores that had to be adjudicated and payable by respondent to claimant. As regards F form, my lords had posed a specific query as to whether that could be handed over even today. And I have gathered information from my client with instructions that back in the day with the different regimen of sales tax and VAT, that could have been done. But today it's too late in the day for us to even approach. Apparently, back in the day also, the reason it could not have been done was because of differences between the parties and certain documents were not forthcoming from the claimant, because of which the forms could not be procured. These are my instructions. And therefore, to that limited extent, I am making the submission to say that a form issue cannot be addressed as things stand today. And of course, the Honorable Arbitrator had in the Section 33 order that he had passed for modification of the award, he went ahead and modified the entire award, contrary to even the claimant's relief that was claimed. In fact, my lords had asked if we could set that aside and address the other issue. And therefore, to that limited extent, therefore, I am now before my lords providing this particular clarification.
Insofar as the hearing is concerned, my lords had directed both parties to sit together and prepare a common compilation. In fact, we have exchanged the documents that we would wish to put in the convenience compilation. In light of this submission, perhaps few more documents may have to be, and on my end, I had requested.
Please.
We'll argue on the merits of the.
No, my lords, no submissions.
Please.
Please.
Please. Please. It is not ready, man. It's about 10 days. Please.
Please. Please. Very well.
10th of February.
Grateful.
22 urgent, 23.
I'm sorry, could we have it post the 14th of February? My lords? I'm sorry.
10th of February.
The 14th, man.
Sir, 17th of February.
Very well. Please. I'm obliged.
23.
But here, respondent has to come on record merits. Notice has been served.
No, sir. Of February.
My lords, there is one correction, my lords. In serial number 23, there is one correction, my lords. The cause list name shows as Hare Krishna Eswalla is no more, my lords. So we are on wakalat. Please, I'll file in a fresh wakalat, my lords. Though I'm in record, my lords. In the earlier, no, my lords, no. Please, please.
Instead of the name of, in the place of, instead of the name of Mr. Hare Krishna Eswalla.
Please.
Yes. Yes.
Great.
Seal number 6, password matter. 6. No, sir, responding.
It's a bit the human care for the second. A fresh movement will be for service or responding.
17 to Till number 13.
Kumar, this is an appeal challenging the order passed by the commercial court, challenging the award passed by the arbitrator, contrary to terms of the agreement. The honorable arbitrator has awarded an amount of around 64 lakhs towards incentive that is not applicable according to the terms of the agreement. I'll request your lords to turn to the page number 70 of the award, 69. That clause has been culled out, my lords. The first three lines will make it clear, my lords. Will make it clear that 12.1, page number 69. May I read your lordships? Incentive bonus is payable for early completion of the work in contracts where specifically provided in the detailed tender notice. I'm so sorry.
69.
Page number 69. This is appeal memorandum. In the physical copy, it shows page number 69. So sorry. I'm so sorry. In the first paragraph number 31, you will use the class 12, which deals with the payment of incentive minutes. The first 12.1. 12.1 minutes. First three lines. Incentive bonus is payable for early completion of the work in contracts where specifically provided in the detailed tender notice, that is tender conditions uploaded in the website. In this contract, that was not uploaded. That is our contention. The learned arbitrator does not answer to this question. He proceeds next paragraph, page number, next page, paragraph 32 onwards, discussion commences. Relevant portion is at paragraph number 33, page number 70. May I read your lordships? If the contention of the learned counsel by the respondent is to be looked in, paragraph 33 minutes, bottom, page number 70. If the contention of the learned counsel for the respondent is to be looked into with regard to 12.6 is concerned, it would deal with the decision of the chief engineer in respect of the incentive bonus. The decision of the chief engineer shall be final and binding on the contractor. In this regard, the learned counsel for the respondent has pressed into service Exhibit R4. A perusal of Exhibit R4 clearly indicates that in the first instance, the claim for incentive bonus was accepted by the respondent, but however, the same was declined on the ground that since the payment of incentive bonus was neither uploaded in the tender notification nor discussed in the TCP. A perusal of clause 12.1 clearly indicates that the incentive bonus is payable for early completion. That is how misread. That arbitrator misreads. Our contention is, it is applicable only if it is uploaded along with the NIT, notice noting tender. No, that is our case. But learned arbitrator, defense matters. That is the only challenge. He had awarded interest that was modified subsequently, matters. May I pass on the defense passed before, because all papers are not before the court, matters. Today it has come. Yes. Defense, I will just show it.
Oh, he must have noted the arbitrator.
Yes, he has noted that clause itself. Yes, ma'am. Uploaded. Yes, ma'am. Yes, kindly turn to page number 62 minutes. So paragraph number 16 minutes. Contentions have been raised, recorded. May I read minutes? It commences from paragraph 15 minutes, page number 62. Insofar as two contentions raised by the learned counsel for respondents regarding accepted matters and no claim certificate concerned, he submits that the no claim certificate was given under duress and such a plea is raised in the pleadings. Insofar as accepted matter is concerned, if the no due certificate is issued under not acceptable terms, the question of the dispute falling under accepted matter would not arise. Next, Mr. So-and-so, learned counsel appearing for the respondent 1 and 2 submitted that the claimant is not at all entitled for the relief sought for. He submits that the claimant invoking clause 12 of the GCC does not arise. He relies on clause 63 of the GCC, which is marked so-and-so. The matters which are referred to in clause 63 are to be termed as accepted matters, and they shall not stand specifically excluded from the purview of the arbitration clause. He submits that clause 43 of GCC relates to issue of a no-claim certificate, and that being an accepted matter. The question of the claimants invoking clause 12 of the GCC does not arise. According to him, there is no arbitral dispute exists between the parties. He further comment, I'm just coming minutes. I'm just coming further minutes. According to, he further contended that invoking clause 12 of GCC, he submits that the incentive bonus clause was not made a part of the tender notice and was not uploaded on the website, and hence the claim is liable to be rejected. This is a specific time. Respondent, I tried to contact him, his number was busy, he did not respond. There is a, yes. And there is a delay of 20 days in filing the appeal minutes. 60 days minutes. It was during COVID period. No, 20 days, yes.
60 days.
Yes.
80 days.
And if he, if he crosses this point, minutes, further submission is he entitled in what rate, that is accept, those things can be discussed later. This is the only challenge. Yes, ma'am. No, we have not yet paid to him. Yes. Yes. And also with interest, we made an application, it was modified. Interest was not paid, awarded. Earlier awarded, it modified, obliged.
Court officer. Court officer.
ಹೇಳಿ ಮೇಡಮ್.
Madam, serial number 15 application allow ಆಯ್ತಾ?
ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಆಯ್ತು ಒಂದು ಮೆಸೇಜ್ ಹಾಕಿದೀನಲ್ಲ ಮೇಡಮ್, ಏನ್ ನಿಮ್ ಕನ್ಫ್ಯೂಷನ್?
ಇಲ್ಲ ಮೇಡಮ್, ಏನು ಏನೋ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಿ ಅದಕ್ಕೆ ಕನ್ಫ್ಯೂಷನ್
ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಅಲೋ ಆದ್ಮೇಲೆ ಒಂದು ಡೇಟ್ ಕೊಡ್ಲೇಬೇಕಲ್ಲ ಮೇಡಮ್. ನೀವು ಅದು ಫೈಲ್ ಮಾಡೋದಕ್ಕೆ ಪೇಪರ್ ಪಬ್ಲಿಷ್ ಮಾಡಿ
ಆಯ್ತು ಮೇಡಮ್, ಅದಕ್ಕೂ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಅಷ್ಟೇ ತಾನೇ?
ಡೇಟ್ ಕೊಡ್ಲೇಬೇಕಲ್ಲ ಮೇಡಮ್ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ಗೆ.
ಹೌದು ಮೇಡಮ್.
ಎಸ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ ನೋಡಿ 24/2.
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
ಓಕೆ.
That's one submission. I contacted the respondent counsel minutes. He said he is out of station. If it can be taken up tomorrow, he said tomorrow, day after tomorrow, he is here tomorrow. Could it be, well, it's only short point. Tomorrow, update. So short point, could it be say? Update. 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 Update.
Seal number 30, Shri Ramesh Chandra.
For the appellants, Your Lordship. On the last occasion, a senior had made submissions. Yes, Your Lordship. If there is any other response after they finish, we'll submit.
If they May it please your lordships. I appear for the first respondent in the second matter, who is the second respondent in the first matter. My lord, the subject property constituted the property of Lakshmi Industries, of which the respondents, their father, mother, and brother were partners. The said property had been mortgaged to State Bank of India, which filed a suit for foreclosure. The matter was compromised on payment of the money. But insofar as the documents of title are concerned, my lord, the bank said that it has lost the title deeds, and in the circumstances it is not able to return the title deeds. My lord, and then this fact is stated in the agreement of sale, which is now sought to be enforced by the appellant. My lord, having regard to this fact, the statement at the bar that we lost the title deed is not fair, is not correct. My lord, this is an appeal under section 37 of the Act. Now, my lord, the scope of appeal under section 37 is clarified in the latest judgment of the Apex Court reported in 1924 7 SCC 218. Lordship, may kindly permit me to read it. 2024 7. I have produced it along with my memo dated 12/9/2024, my lord.
Volume 2. Volume 2 of the list of the.
Volume 2 of the citation.
Second volume.
Yes.
My lord, you'll read paragraph 26, my lord. My lord, paragraph 26.
Yes.
Jurisdiction of the appellate court dealing with an appeal under section 37 against the judgment in a petition under section 34 is more constrained than the jurisdiction of the court dealing with a petition under section 34. It is the duty of the appellate court to consider whether section 34 court has remained confined to the grounds of challenge that are available in a petition under section 34. The ultimate function of the appellate court under section 37 is decided whether the jurisdiction under section 34 has been exercised rightly or wrongly. While doing so, the appellate court can exercise the same power and jurisdiction that section 34 possesses with the same constraints.
Yes.
My lord, having regard to this judgment, what is the scope of section 34 will have to be called out. My lord, I have filed a compilation of citations. Volume 1, my lord. My lord, this is the first judgment is associated builders case, which is repeatedly referred to in the apex court judgments.
Yes.
May I invite your lordship's kind attention to at page 19, ink page 19, my lord. Paragraph 17. It will be seen thus that none of the grounds contained in subsection 2A of section 34 deal with the merits of the decision rendered by the arbitral award. It is only when we come to the award being in conflict with the public policy of India and the merits of an arbitral award are to be looked into under certain specified circumstances. In Renu Sagar's case, my lord, I'll pass over that. Now kindly turn to page 20.
Mr. Chalapati.
Yes.
We'll come to the law later. First, you come deal on the facts. See, every law, every judgment has to be read in the context of the facts which arises for consideration in a particular case. So we'll come to law. Law, in any case, 34, 37, we know the jurisdiction. But let's see what are the facts and what is your case on merits, on the facts.
My lord, my submission is this. My lord, the court in a claim for specific performance must consider section 16C as also section 28. My lord, I will later on invite your lordship's kind attention the scope of section 16C and 28. My lord, 16C, one of the things to be considered is whether the plaintiff who seeks specific performance must plead that he has always been ready and willing to perform his.
That's right. Let's see that. Let's see that.
Yes. Then, my lord, section 20 requires the conduct of the party to be looked into. My lord, the law laid down by the court says the funds must be available with the plaintiff throughout at the time of the agreement. Meanwhile, during the pendency of the proceedings, and then at the time of the decree. Whether the arbitrator's award satisfies this is to be seen.
Yes.
My lord, before I take your lordships to these things, can we first read the agreement of sale, which I have produced in volume 1. Agreement of sale is marked as C4 at page 1.
Agreement. Agreement to?
Yes, my lord. My lord, this loss of documents is recited in this agreement itself. They say it is lost. Then, my lord, the operative parties at page 5.
How many volumes? Okay, these are basically on merit. Okay.
Yes.
Let's see that. Page 1, that's the agreement to sell.
Yes. My lord, this loss of documents which I mentioned is recited in this agreement of sale. And then, my lord, I may also mention the claimants in this case, that is, the appellants in this case, appeared for Lakshmi Industries, of which I am a partner, as our advocates. and they were fully aware that the documents were lost by the bank, and they have stated so in the agreement of sale. Then, my lord, could your lordship kindly turn to page 5, the operative part,
Yes.
part. The vendors
Yes.
have agreed to sell the scheduled property at the rate of rupees 1,000 per square feet in respect of the scheduled property. The parties shall get the measurements of the entire scheduled property for finalizing the total sale consideration. On record, the measurement is stated to be 43,600 square feet. The purchaser have agreed to pay sale consideration as follows: a sum of 30 lakhs paid in the names of 3 vendors at the rate of 10 lakhs per vendor. My lord, this is paid. Then B, a sum of 120 lakhs shall be payable at the time of registering the document in the name of the vendors at the rate of 40 lakhs each, payable either by the purchasers themselves or their nominees. The purchasers agreed to pay the interest of 6%. Then, my lord, the remaining amount is payable within 1 year from the date of the agreement. In case the vendor requires the amount for buying any property, the purchaser shall arrange for adequate amount for the purchase of the property from the balance agreed amount payable after the registration of document, and not wait until the expiry of so and so. The vendor shall reimburse all expenses, my lord. Then 4, that is important, my lord. The registration of the sale deed shall be finalized by the purchasers by paying part of sale consideration of rupees 120 lakhs on or before 30/6/2006. My lord, there are 2 crucial dates. One is document to be registered on or before 30/6/2006. Although I have not received the full sale consideration, if they don't pay, my remedy is to file a suit for recovery of money because I have lost the property. My lord, this submission for the purpose of considering whether this agreement is fair, more so because they were my advocates. Then the entire transaction is to be completed within 1 year. My lord, that will take us to 15/4/2007. My lord, the question would be whether either on 36/2006 or on 54/2007, whether the appellants had enough money to pay and complete the sale consideration is the question. My lord, I may say at this stage, if the judgment, if the award of the arbitrator is perverse and no reasonable person could come to that, that is the ground for setting aside, having regard
Yes.
to associated builders case. My lord,
Yes.
now kindly see the award. Appeal memo, appeal memo.
Is 105.
222. Yes. Could your lordship kindly turn to page 222 of the appeal memo?
Yes.
My lord, the last paragraph at that page. Further, the claimants have exhibited their Canara Bank Savings Bank passbooks pertaining to their individual savings bank accounts maintained as per Exhibit C5 and C6, which indicates that both claimants had credit balance of over 50 lakhs each in their savings bank account. from 6/10/2006 to 16/12/2006. My lord, sale deed is to be registered in June 2006. 36/2006.
Yes.
As they had no funds at all for making payment of amounts to me. And it is only on 6/10 October, the sale deed is to be completed in June, whereas they have put 50 lakhs, my lord, on 6/10/2006. My lord, even that 50 lakhs which they say that is in their account is paid to somebody else in December 2006. My lord, your lordship will get here. I may have to invite your lordship's kind attention to C5 and C6. My lord, I may state at this stage, there is a controversy regarding this C5 and C6. According to us, only an extract, pass of the passbook is produced according to them. They produce the full passbook is their case.
How many volumes you are filing?
It does not make any difference, my
You
lord.
should file it in one compilation. We can't manage all this.
I have filed by compilation, my lord.
No, we are only saying that we can't have it in different piecemeal and different. We want in one compilation. One gets, suppose, out of these, this
We have
thing,
divided everything. Memo of citation, we have filed one compilation.
you will do one thing, give one spiral,
Yes.
and put an index.
Yeah, we'll do a
But
convenience.
Everything, you know what is there, but
Yes.
it should be in one spiral.
Yes.
My lord, instead of giving separately, we will put it in one book and give it.
Yes, that's what we are telling your briefing council.
Yes, my lord, we will do that, my lord. We will do it. Kindly give us some time, we will do it.
Yeah, surely. No more, I suppose? Or there are? How many?
There are two more. One is regarding evidence that is still there.
And you have put the volume numbers also? No.
Volume numbers are on the top, my lord.
Okay. Very good. But we want one volume.
Yes, I understand.
Yes. It is same. You have two volumes, one Roman volume and one numerical volume.
One is only citations, my lord. The other one is all evidence and other things.
Yes.
My lord, exhibit C5.
Yes. Let's see, which is the one which you are referring to, Mr. Chalapati? Exhibit C5?
C5, my lord.
Okay, let's see that.
C5, there is no deposit of 50 lakhs. They don't have any money at all in this. So the observation of the learned arbitrator that each of them has 50 lakhs is not correct.
But tell us, how relevant would be this submission when you say so the sale deed was lost, the title document?
Title documents were lost by the bank, my lord.
Very well, it's all right. But that is your case also, it got lost.
Yes.
Very well. If it is lost, is it your case, was it your case that this deal cannot go through because you have lost the title documents?
My lord, the appellants in this case were prepared to purchase the property because they were fully aware that title deeds are lost by the bank. They say they even prepared the draft sale deed and gave it to me, and I delayed registration.
Yeah, but
So
they
far
were
as
still,
me and the appellants are concerned.
they were still ready to purchase that property.
Yes.
Okay.
That is why
So your case is, even though the title document was lost, but the appellants were ready to purchase the property, but they were not, the ready and willingness was not depicted as they don't have money.
Yes. Actually, there is no money at all, my lord. Absolutely no funds.
Okay. But how would you explain one of the shares of the property, the shareholder has settled the issue
My lord, one of my brothers,
Yeah.
he has sold the property long after the award is passed. And at the time of the award also, there is absolutely nothing to show that the appellants had funds.
Okay. Okay. The property is divisible by meets and bounds?
It is already partitioned, my lord.
It's already partitioned.
It is already partitioned.
Okay.
Partition is accepted by the appellants. They have purchased the property of my brother, which
Very
is
right.
separate from the other two property.
Very right. Okay. Let's see. Yes, Mr. Chalapati, what do you want to show from C5? They didn't have money of 50 lakhs.
Yes, C5, 50 lakhs is not available.
It's
Then
not available.
kindly turn to C6. Next page.
Yes. How much was available? Okay.
50 lakhs deposited.
C6 C6 no man. Next. No,
But if you turn over the page to,
Yes.
yes, page, this would be, if you see against the date,
10. 50 lakhs.
19/12/2006,
Yes.
how much is the figure depicted?
19. Even these 50 lakhs they had, they paid to Bindu from Bindu promoters.
No, it says Venkatalakshmi.
10 lakhs. That is paid 10 lakhs.
Okay.
These things, 50 lakhs.
Out
That-
compilation.
Huh?
Is not getting it. The point is, my lords, those exhibit P5 and P6 are produced to show 5 lakhs has been paid to each of the claimants. It is not been produced to show that 50 lakhs was available on the day. In fact, the documents available on record, if my lords could see, it contains only 2 pages. What is been given to my lords under the compilation now contains many more pages than what has been produced before the arbitral tribunal is what
This
exactly
is not
P5.
50 lakhs. Is it 50 lakhs?
It is 5 lakhs, my lords. 5 lakhs been given to each of the,
No. It's 50 lakhs.
my lords, my kindly.
It's 50 lakhs.
Exhibit P5 contains 3 entries over there.
No. Come to page 171 of this compilation. Against the date 19/12/2006. How much you would find?
My lords, we have only 1 pages of the compilation. No, my lords, we have only, even we have checked the file yesterday.
You appear for whom?
I appear for the first respondent in the matter because he is arguing for the second respondent.
Mr. Chalapati is arguing for you only.
No, he is arguing for him.
Acha, okay. You are which respondent?
I am the first, he is the second respondent.
I'm second respondent, madam.
Okay.
Second respondent.
You are at variance.
No, I am not at variance, but documents available on record is been different from what is that is been given to my lords for that.
No, you are they are filing it. They are filing it.
But this is the only document available.
We don't know.
May I clarify, your lordship?
Yes.
Lordship, exhibit C5 and C6, when they were marked before the learned arbitral tribunal, the entire passbook has been marked, which is what is there in the evidence. But what happened was during the course of compilation before the arbitrator, they have, while making that compilation before the arbitrator, convenience volumes, that time only the first pages have been marked, compiled in the paper book. But actually the entire passbook has been marked, which is also there in the evidence. Now, what has happened, your lordship, is this argument that the first page, what they have referred before the 34 court is only the convenience compilations, because what the learned arbitrator did was, after marking all the documents as exhibits, they were returned to the parties. So in this case, at the time of marking the documents in original proceedings before the arbitrator, entire passbooks were marked. But because the convenience compilation did not have all the pages, For the very first time in the final argument stage in the section 34 petition, first time they take a stand that entries are there only from this date to this date, which is in the convenience compilation. Then we made a submission before the section 34 court that in fact entire passbooks were marked, and they cannot also take a stand that 50 lakhs as observed by the learned arbitrator is not there, because one of the bank statements have been marked by the respondents as their document. So they very well knew that these passbooks which we have, they had the amount of 50 lakhs. But now at this juncture, an argument is sought to be made that the exhibit was not complete, or in this regard, I'll make. Yes.
On, my lord, the money required to be
Lordship, it is
seen the
one
date.
One thing to say that whether 50 lakhs is sufficient, and another thing to say that there was no money at all available. These two different. So
We've answered it, sir, when it comes to me. Lord, that question is 36/2006 is the date. That is what required to be seen. It is available only after in the month of 10th of October of 2006, even assuming their argument is correct. We'll address it, my lords. We'll address it.
That's a different argument.
That's a different, but
What is the relevant date?
36/2006 is the relevant date. 34/2006 is the relevant date.
30th of June.
40 lakhs to each should be paid by
1 crore 20 lakhs on 36/2006.
So on that day there was no money.
There was no money. That's what
money.
exactly
No
our
money.
argument is.
Subsequently. It
No
had come
money.
subsequently.
It came subsequently is our argument.
Oh.
That's it.
My lord, your lordship, I kindly
Ready
see
and willing, yes,
this
sir.
R33. In fact, their appeal memo says the trial court ought to have relied upon exhibit R33. In R33, your lordship will find 6/10/2006, 50 lakhs is deposited.
How much?
6/10/2006, 50.
How much have been deposited? 50 lakh
Right.
deposited.
Much in the case.
That is in October.
Yes, but the amount ought to have been paid in June. Then, my lord, even this money, they did not keep it. Your lordship, I kindly see next page. On 9/12/2006, they pay these 50 lakhs also to Bindu promoters. So as on the date of the award, absolutely no money, absolutely no money.
Where is Bindu promoters?
1912.
19/12/2006 to Bindu promoters, they pay
Yeah,
50 lakhs.
50 lakhs.
Yes,
Who is Bindu promoters?
somebody else, my lord, not connected with this.
Okay.
So 36/2006, there was no money. It is only in October 50 lakhs.
Who is Bindu promoters?
Your Lordship, that's another transaction which is happening.
What is that transaction?
Your Lordship, there is no question that has been raised on this
Oh,
aspect.
we want to know. You have relied upon.
Yes, I will.
We want to know. See, the difference is between October it had come the money, June there was no money.
Yes,
October came, December went out.
yes.
Now, how did you get this money? Did you get it from Bindu promoters?
Yeah, I'll seek instructions and make submission.
Yes.
My lord, may I continue reading at page 222, my lord?
Yes.
Yes, even that means the claimants had more than sufficient financial resources and avenues to mobilize the consideration at any point of time to meet the contingency. In fact, the money goes out. This fact was also in the knowledge of the second respondent as evidenced by R33. My R33 also says the same thing. Money comes only in October, goes out in December, which is a bank passbook extract belonging to first claimant, maintained at Canara Bank. produced and marked by the second respondent, wherein it is reflected that the first claimant had deposited a sum of 50 lakh in the savings bank account on 6/10/2006, which sum was available till 16/12/2006. My lord, then.
1 minute, Mr.
Yes.
Chalapati, what is the finding of the 34 court or the 30 or the arbitrator on this 50 lakhs? Is there any finding on that?
May I submit your lordship? May I submit your lordship on this aspect, whether the money should have come and whether money has come and gone out? What are there is no pleadings on that at all. There's no cross-examination which is done on that part.
But is there any finding of the arbitrator?
No, your lordship. On this Bindu promoters, where that money has come to where it has gone, there are no findings of the arbitrator.
What about 50 lakhs finding?
That the arbitrator has recorded.
What does it say?
Saying that 50 lakhs was there in the account as reflected in the bank account of the
But does he
claimant.
say so? What was the relevant date?
Lordship, what the arbitrator states.
No, in terms of agreement to sell.
Yes.
What were the obligations?
Your lordship, in terms of the in terms of Exhibit C4, the payment had to be made in 3 tranches. The first is as on the date of the agreement. The second is at the time of registration. The third payment is after 1 year. At the time of registration.
Third?
And third is within 1 year from the date of agreement to sell.
Okay.
These were the 3 stages of payment. And the law under Section 54 of the Transfer of Property Act, parties can have a consideration in a manner which is agreeable between the parties. In this case, what is undisputed is that insofar as the payment which is done on the date of entering into the sale agreement, that has been paid. Now, as far as the second payment, which is that it had to be paid on the date of registration, the registration never happened. Now, why was there a delay as to why the registration did not happen was because, your lordship, there were reciprocal obligations which had to be performed by the respondent. Now, because these reciprocal obligations were never performed, therefore the entire milestones got delayed. And notwithstanding the 3 tranches.
What were the promises they were to perform?
Your lordship, the arbitrator has given a detailed reasons, one of which was that the respondents had to execute a power of attorney. Now, this power of attorney was also for the fact that because the title deeds had been lost of this particular property, they had to give the power of attorney. In fact, the third respondent before the arbitrator, learned arbitrator, who's the first respondent herein, had also undertaken to execute a power of attorney. So the learned arbitrator takes note of this fact that why they have not executed the power of attorney. The other difficulties are, your lordship, that they have not got the property converted. The genealogical tree was not given. There was also a high tension wire which was there on the property, which unauthorized construction, which was unauthorized pole which was erected. And the first respondent writes to the BESCOM for removal. And in this whole fact situation, your lordship, the respondents themselves had approached another lawyer who's also examined as RW4 before the learned arbitrator. They have sought for a legal opinion on this property. Now, that learned advocate gives certain pointers. What are all the documents which are required in respect of this property, including one of the terms in that opinion was that they have to lodge a complaint, police complaint. They have to take a paper publication in the newspaper.
The loss of title deeds.
Yes, for the purposes of loss of title deeds, because it was an admitted fact that the title deeds have been lost by the bank. Now, all these have taken at least till the month of October, and which the learned arbitrator has noted. Now, because reciprocal obligations were not performed, therefore all milestones got delayed.
Okay.
Yes.
My lord, kindly turn to page 223. It makes more interesting reading, my lord. Third line from the top of 223. The claimants for practicing advocates for more than 2 decades and are also income taxpayers, and those passbooks clearly go to show that they had sufficient balance also in their bank accounts. This aspect clearly substantiates that they were capable of meeting any eventualities required in any situation to mobilize money at the required juncture to meet such eventualities. My lord, just because 2 decades practice, they had to pay more than 3 crores. My lord, I
4.36 crores. 4.36 crores.
അപ്പോൾ കുത്തിದ್ರೆ ಮತ್ತೆ ಹೇಳಿ.
Yes.
My lord, I wish this becomes true. Advocates with more than 10 years are capable of purchasing properties worth 3.5 crores. This is the basis of finding that the claimants were always ready and willing to perform their part of the agreement. They had the funds. My lord, this was the entire transaction not to be completed in 2007. Award is 2014, 7 years. Absolutely no document is produced to show that they had the funds to complete the transaction.
Okay.
My lord, this I would submit
Yes.
amount to a perverse finding within the meaning of associated builders.
Go ahead, Mr.
Go ahead. Continue.
My lord, both this honorable court and the Supreme Court has held that the conduct of the parties should be not impeachable. It must be clean, is what both the Supreme Court and our High Court has said. That is for the purpose of Section 20 of the Act, which was amended in 2018. It has only
Yes.
prospective effect. And so this matter is governed by Section 20 before amendment. My lord, there is one
Okay.
significant factor. There are two agreements, my lord. ಅದೆಲ್ಲಪ್ಪ ಅದು agreements ಕೊಡಿ. I have read your agreement of sale. Now kindly turn to page 8 of that volume, Memorandum of Understanding. This is marked as Exhibit R2. This Memorandum of Understanding is made on this 16th day of April 2006. 3 KJ Kamath aged 47 years and KG Kamath aged 42 years, both sons of so-and-so. Sri Guru Prasad, son of so-and-so, so-and-so, to Venkatalakshmi Parthiban, second party, and then Vardhini is also there. That is the respondents, all the three. Then I will read from the bottom of that page. Whereas the parties of the first part have purchased the scheduled property. By this date, nothing has happened except agreement of sale from the parties of the second party. And in spite of execution of sale deed, there is no execution of sale deed. The parties of the first part, they are unable to pay to the parties of the second party, have promised to pay subsequently by creating proper security for the balance amount. The parties of the second party have accepted the sums upon it is mutually and unanimously as well as four-partedly agreed, paid 20% of the sale realization amount to KJ Kamath and KG Kamath individually at the rate of 10 each. This offer is made by the second parties in recognition of the meaningful association with the vendors for the last 15 years. In each period, the second parties have availed various services from time to time, including services rendered in the lifetime of late Sri Krishna Kumar and late registrar. The balance amount remaining unpaid after registration of sale deed payable to the vendors shall be properly secured by issuing post-dated checks as well as creation of charge therewith and pay the sold to purchaser. Purchasers agreed to arrange funds from the balance sale consideration for the vendor sold. So out of what was agreed was 1,000, it becomes 800 because 20% is to be paid to them.
Yes.
My lord, the respondent filed a complaint to Bar Council.
Volume 4. Volume 4, separate.
Which is in volume 4. Now, with regard to this memorandum of association with regard to 20%, the stand is this, my lord. Would your lordship kindly turn to page 8? Yes, page 8, my lord, volume 4.
Volume 4, Roman 4, you got post property.
Volume 4.
Kindly turn to page 8, my lord.
Yes.
Paragraph 15. The Vardhini, Srimati Vardhini has fabricated with the advice of her advocates, Sri Kiran V. Ran and Sri Pumacha, by titling the same as Memorandum of Understanding dated 16/4/2006, we submit that we have not entered into any Memorandum of Understanding with Srimati Vardhini on 16/4/2006, and the photocopy endorsed by her in the complaint is fabricated, and we call upon her to prove the same. So the allegation is it is fabricated. My lord, unfortunately, the notice was issued by these advocates on behalf of Vardhini, so they are targeted. Then, my lord, after that, in
Yes.
then, my lord, kindly turn to page 17, paragraph 15, in the evidence. Paragraph 15, my lord. Srimati Vardhini has fabricated a document, the advice of
Evidence. You are reading paras. 15
paragraph
and
15, my lord,
17.
page 17.
Yes, yes.
Srimati Vardhini has fabricated a document with the advice of her advocates Sri Kiran V. Ron and Sri Punacha by titling the same as Memorandum of Understanding dated 16/4/2006. We submit that we have not entered into any Memorandum of Understanding with Srimati Vardhini on 16/4/2006, and the photocopy enclosed in her complaint is a fabricated document, and we will call upon her to prove the same. Now then kindly come to cross-examination.
Yes.
Would your lordship kindly turn to page 24, bottom paragraph 7. This fabrication theory goes. In the meantime, the complainant requested us that she is planning to create a certain permanent memorials and endowments in the name of her deceased father and brother, as the entire property was acquired and maintained by them without any efforts, and the other brother and sister of complainant. With a view to achieve this object, the complainant requested us to create one more document so as to show the value of the sale is fixed at 800 per square feet, as the move taken by the complainant was not acceptable to her husband and father-in-law, so that she can retain an addition of 250 per square feet in each to be shared between herself and her sister Venkatalakshmi without the knowledge of her husband and family elders. For this reason, the complainant had kept her husband and father-in-law away for negotiation. Since the agreement was agreed to be 1,000 per square feet, we, hesitatingly executed the document. Earlier stage is fabricated. Now we executed the document requested by the complainant. Subsequently, we learned that the complainant was hatching a plan to retain additional sum of ₹200 with herself and would not share it with her elder brother, Sri Guru Prasad. On learning this, we told the complainant that we will not be acting upon the memorandum got signed by her, and the same is to be ignored and treated as cancelled. And accordingly, the original of the said document was cancelled and nullified immediately thereafter. As a result of our original agreement of paying the amount though demand draft at the agreed rate of 1,000 per square feet prevailed. As such, exhibit C12 produced by the complainant has no relevance and was not acted upon at any point of time, right from the date of execution, and the same was created at the behest of the complainant without understanding actual thing. My lord, the earliest and it is fabricated with the assistance of our advocates who issued notice prior to suit. And here it is created. Execution is also admitted. My lord, this is the conduct that requires to be considered under section 20. My lord, what the arbitrator does is, then my lord, bar council barred them for 3 years. Then on a review, it is reduced to 3 months. The matter is pending in the Supreme Court now, as of now. My lord, without considering this conduct, what the arbitrator does is, he assumes the jurisdiction of the Supreme Court and says there is no misconduct at all. He refers to the Advocates Act and other things and says that there is no misconduct at all. My lord, is it permissible for the arbitrator to say so and go into that question about which he has no jurisdiction?
Yes.
My lord, these are the points. No funds are there, and the arbitrator does not consider this conduct, but considers whether the misconduct which is now pending before the Supreme Court is correct or not, and says there is no misconduct at all. My lord, for these reasons, I would submit that the award is perverse in the sense as held by the Associated Builders case, and as such, the trial court has considered all these facts and has written a very well considered order, my lord, after referring to all the judgments cited before him by us and by the other side.
Okay, that's it. We'll continue after vacation.
Kindly,
Just say that we have heard Mr. Chalapati.
My lord, I will file a memo. I will compilation. I will file it, my lord.
No, we would be only, you would also file your brief note of submission, Mr. Chalapati.
Very well, my lord. Very
And
well.
giving reference to all the judgments we have referred to.
Yes, yes, my lord. I will do it.
And there would be one compilation, not how many? 5 or 6?
Not.
Six. Make it one.
So I have certain points to be noted after vacation.
Yeah.
I have certain points.
Lordship, I also, on behalf of the appellants, all these issues have been considered by the arbitrator. I'll make my.
You will also file your submissions. File your submission. We'll hear you.
Yes.
Yesterday to come up for the Mr. Chalapati for respondent number 2.
Respondent number 2 in first matter.
To come up for the submissions of the other respondents.
Only one respondent, that is
The remaining respondent.
McKay.
Okay. Re-notify. Just give a date. Any Friday, ma'am. Should be. You have the calendar. We'll have 17th, 14th February. February. 14th February.
McKay.
Thank you.
If your lordship will treat it as a part heard matter.
Our orders will speak. Okay.
Okay.
Thank you.